let's look at the second case study we have about the use of the credit shelter trust, which again is kind of the big, that and the life insurance trust are the two major ways of preserving assets from the federal estate tax. In this second, the numbers are the same. The numbers add up the same as in the first one, but rather than the wife having $1.8 million in individual names, that property, that 1.8, is now possessed in joint names. So you'll see it's very similar, but it has that little wrinkle to it. Now, what are our observations? They're not using, by having it in joint names, by having property in joint names, they're not going to maximize their individual $2 million exemptions, all right? You've got to individualize property to maximize the use of your $2 million exemptions, which, by the way, January 1, 2009, the $2 million goes to 3.5. January 1, 2010, it goes to no federal estate tax. For a year, 2010, there is no. So if Congress doesn't act, that's how the law was passed. It was a compromise back several years ago. And to force Congress to act, they put this sunset provision in whereby if Congress doesn't act, you're going to have federal estate tax. To January 1, 2011, it goes back to $1 million. A whole lot of very upset people who are faced with $1 million federal estate tax, which if you have a nice home and a decent life insurance policy and some savings, you can pretty easily get beyond in today's era. So just we talk about $2 million, that's good for now, but you know, it is going to be changing. And in fact, before we started, I had a question from a member of the audience about one aspect of the night. You'll know more than I do, because you know, who wins the presidency, who wins the Congress will have some effect upon what direction these are going to go in, because Congress is likely to change the law from that going back to $1 million, but it's a question of where it will end up and how that will end. So we'll all have to stay tuned. If the wife dies first, her $2 million of exemption is effectively wasted, federal tax law, and if there was any talk about changing it, and I said, well, you probably, if you watch the election results, because she has no assets in her sole name that pass under the will. This is in her name, the 401k, but it doesn't pass under the will. Why? Because just like property in joint names, it passes through some other mechanism. If it's in joint names, the law tells you where it goes. It passes by operation of law to the joint owner. 401k plans, life insurance, they go to the beneficiary designation. You know, where however you have filled out that beneficiary designation is where that money goes. It doesn't go through your will to people. And you could say a zillion times in your will, I want my joint property to pass to, you know, the SPCA. Too bad. It doesn't matter. It doesn't matter how many times you say it. It passes through that joint ownership and not through the will. Okay, in that example that we're looking at, if the wife predeceases the husband under that asset structure, no assets pass under her will to the husband because she doesn't own anything individually. On the husband's subsequent death, his estate is worth $6 million. Everything in his own name plus everything that he got when the wife died. The 1.8 million in joint investments, the 200,000 in 401k, the million, assuming he was the beneficiary of the life for your kids. That, you know, because here, the $6 million less the husband's $2 million exemption leaves $4 million subject to federal estate tax and a proper life insurance policy. So, you know, he's worth $6 million, you know, which sounds real good until you die. Approximately $1.9 million in federal estate tax will be due. And won't your children think fondly of you as they're writing that check to the federal government or whoever it is that you're trying to leave your money to? What's the solution? You put that $1.8 million that's in joint names in the wife's name alone. There's no gift tax. There's no issues that go with transfer of that into the wife's sole name. the wife names the husband as, names the trustee of the credit shelter trust. Again, you're going to be using that option number 1, that credit shelter trust. So the wife names the trustee of the credit shelter trust as the beneficiary of her 401k. When she dies, the $2 million will pass to the credit shelter trust. The 1.8 in her own name and the $200,000 in her 401k that she says goes to my credit shelter trust. She has to fill that out at work, saying, the beneficiary of my 401k is my credit shelter trust in my will. On the husband's death, his estate is worth $4 million. $4 million less the $2 million exemption leaves $2 million subject to estate tax. But if you use an ILIT, that for each of their life insurance policies, that $2 million, one from the husband and $1 million from the wife, each pass through the ILITs to a trust for the surviving spouse, and then typically to the children or wherever you want, and it's all exempt. So, in one scenario you're paying $1.9 million in the carefully crafted plan, you're down to zero, which isn't a bad deal. Okay, disclaimer trust is one of the few things that you can do in a meaningful way post-death that allows tax planning. Really, almost everything you have to do before you die. But the disclaimer trust allows someone, for example, the spouse, the surviving spouse, to say, I don't want money, and or I don't want the real estate, or I don't want property in joint names, and it then, under the will, if the will is properly drafted, to have a disclaimer trust. It allows the money to go into a disclaimer trust that operates like a credit shelter trust. And therefore you get to use that federal estate tax exemption. Disclaimers are a little bit complicated. You've got to file them in a timely way. You can't use the property before. Just having that disclaimer trust in the will, where post-death the spouse can say, I don't want money, I want it to go into the credit shelter trust, or into the disclaimer trust, and you got to plan out how you do it. But properly used through it going to the will can be very helpful. For example, in this scenario, the wife could disclaim that $1.8 million. Let's say when the wife dies, the husband could disclaim it, allow it to go into a disclaimer trust so long as there's one in the will. It operates like a credit shelter trust. It's kind of a fail-safe where perhaps some other planning hasn't happened, or people got money, they didn't get their wills redone. There's a variety of reasons why it can happen. It's a good idea to at least consider the use of a disclaimer trust. They're a little complex. Over the years, many people have not included them in wills. We're including them more now than we used to, in part because, I think some people used to fear putting them in, that individuals would goof them up by not appropriately disclaiming or using property in an inappropriate way to preclude a disclaimer. But it is a tool that at least should be considered in estate planning documents, and we are now starting to use them more frequently. It operates virtually identically to insurance trust. Special needs trust is an incredibly useful tool where a beneficiary of your estate has special needs, particularly if that individual receives some sort of public benefit like medical assistance, supplemental security income, mental health, mental retardation benefits, because if you just leave money to those individuals either outright or in a, what I call, get under any circumstance. If you're leaving money to anyone who has a disability, almost always you'd want to use a special needs trust as part of your estate planning, because otherwise you are disqualifying them. A garden variety support trust, for the support, health, education, welfare, you will have disqualified, and many times you've effectively given the money to the government if you leave it to a person with disabilities who's on public benefits. Minors Trust provides a mechanism to maintain resources by a trustee on behalf of minor children, and we call them Minors Trust, but hey, I've done Minors Trust for people up to close to 50 years old, where the family doesn't really, they're not disabled, but they have to be just for someone under 18 or 21. And in fact, in most of the Minors Trusts we create, we have no distribution of principal outright to people. I mean, the trustee can pay for things like college or transportation or whatever, but we don't have outright distribution until they don't want their offspring to get too much money too soon. So we call them Minors Trust, but it doesn't. The last child turns 25. Even then, I'm a little shaky, but that's the age we use. Yes, sir.
Under the Special Needs Trust, particularly, what powers does the trustee have?
The trustee has absolute discretion to spend the money on anything that has a reasonably direct connection to the special needs of the disabled person. And in fact, on our website, we have the ABCs of uses of special needs trust. You can buy an automobile if the person has is able to drive. B, beach passes. You can buy entertainment expense. You can buy furniture. You can buy computers, electronic equipment. You can pay for therapies, dental, eyeglasses, pretty much anything related to the bona fide needs of the individual with disabilities. They are fairly broad in the scope of their use, and broader than sometimes the term special needs trust might suggest. So it's not just for therapies, but as I say, it could be used, for furniture and transportation, attendant care, to help out the individual with disability, education, training, virtually any type of programming or device that could enhance the quality of life. Does that answer your question?
Thank you.
Thank you. And in 2 weeks, we're devoting much of our next seminar to special needs trusts, and going to talk about those in depth. Power of attorney. In most cases, that's provided between spouses, from one spouse to another, but it provides financial and medical authority to whoever you want to designate to act on your behalf. Most notably, they're used when someone's incapacitated, but it doesn't have to be. I mean, sometimes the power of attorney can be used to sell real estate or buy real estate when someone's out of the country. So it's an extremely useful tool and extremely important to avoid the need, if someone does become incapacitated, of running to make medical judgments on behalf of the disabled individual for exploratory surgery, for elective surgery, court in a very cumbersome and expensive guardianship proceeding to get authority for transfer to a nursing home, all kinds of